All right. Okay, Melissa, take it away.
All right. Hello. Thanks for joining us on our Monday, April 12th meeting. We have Harland Law Firm today, correct?
Yes.
And Amy as our guest. And today we're going to have Becky Giacomini lead us in the flag salute, please.
Okay, where's my flag? Oh, well, wait a minute. There it is. Okay. Salute. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Awesome. Great. Thank you, Becky.
Becky.
All right. Do we have any new members with us today?
Yes, Amy.
Any announcements today? We had a fundraiser, and we all are reeling from our lasagna hangovers. So, Renee,
okay,
anything?
Okay, so we'll switch from lasagna to tri-tip. Well, you know, beef, it's what's for dinner. Just a shout out to Sunrise Rotary is doing a fundraiser drive-through on May 22nd. Let me bring up my little thing here. It's a fundraiser for Fortuna Volunteer Fire Department, and it's on May 22nd, and they're going to have wonderful tri-tip dinner, and more information will be coming out. They're just finalizing all the plans, but they do have the date. And so you do drive through the fire department parking lot, and it'll be a wonderful dinner. And I think right now it's at $75 a couple, and great tri-tip, beans, salads, bread, dessert, that kind of thing. So anyway, I'm just giving a little shout out just as it's starting, but you'll get more information, and I'll forward the stuff to you, Renee, so you can see a poster.
Yeah, and then I can share it with the members. Great.
Yeah.
Awesome. Okay. So piggybacking on that fundraiser, with our fundraiser, thank you to everybody who came out Friday. It was, we had over 100 meals. We had a bunch of volunteers from the skate park. We had these kids running around selling raffle tickets that night, and the skate park had t-shirts and stickers for sale, and we're taking donations. And so thank you everybody who came out. I mean, it was so great. And it went off pretty flawlessly, I have to say, because we had a ton of volunteers and it was great. So thank you to everybody who came out. Of course, Jeannie, Doris, and her daughter Angie and their staff for putting all those meals together. Gosh, what an undertaking, but it was so delicious. And then Monica and Melissa from Fresh on Main Street for those gigantic cupcakes, which were super delicious. Just great. Thank you, everybody. I'm going to bore you right now with thanking all of our sponsors, so bear with me. I just wanted to give a shout out because without our prize sponsors, none of this would have been possible. So I have my list, so bear with me. Hops and Humboldt, of course, who kicked off those skateboard packages, which was amazing. Sport and Cycle, McLean Foundation, North Coast Journal, Umpqua, Coast Central, AM Baird, and Went Construction also donated towards those 27 skateboard packages, so thank you for that. Eel Valley Appliance, Humboldt Grass-Fed Beef, Bear River Casino, Pat and Kathy Whitchurch, Seahawk Fishing, Benbow Historic Inn, Roach's Automotive, Hummel Tire and Wheel, Ferndale Tech, Jitterbean Coffee, Eel River Brewing, Horizon Business Products, Dennis Scott, Glowmore Skin Studio, Chris Broadstock, C. Crane, Humboldt Redwood Company, Humboldt Distillery, Redwood Coast, Redwood Capital Bank, Ray's Quality Cars, Vacasa, and Peterson Cat. Thank you all so much for donating to the raffle, and congratulations to the 47 winners of our raffle. We went live on Facebook, so you can watch the replay on our Facebook page if you missed it, and then we'll be reaching out to everybody today and tomorrow to tell them how to collect their prize and to let them know what they won in case they missed the Facebook event. And then let's see. Just to let people know, we were talking about this earlier before we went live. The county has opened up vaccinations to 16 and older. They are utilizing the myturn.ca.gov platform for checking for appointments. Currently, there are appointments available in Eureka, at Providence and the Safeway Pharmacy, and also in Arcata at the Arcata Community Center. So just go to myturn.ca.gov, fill out the information, and they'll let you know available appointments in the area. Hopefully we'll get Fortuna on that map soon. And then next Monday, our featured guest is Sean Todd. He is the Fortuna Community Garden Project Coordinator for Fortuna Adventist Community Services. He's going to talk about what they do and how they have taken over and relocated the community garden. So that's next Monday at noon. And with that, I will send it back to Melissa.
You don't want me to talk, the dogs are barking. But I am actually just going to introduce our guest today, Amy Mendoza Stover from Harland Law Firm. So please take it away, Amy.
All right, thank you so much. So I'm Amy Mendoza Stover. I'm one of the partners of the Harland Law Firm, and I practice mainly in the area of estates, wills, trust, and probate. We are celebrating our 75th anniversary of the firm this year. I guess on about March 10th, 1946, Collis Mahan, also known while he was at Humboldt State as Flash Man, returned back to the hometown of Fortuna and opened a solo law firm. And after his tour as in the Air Force, Gerald Harland on the GI Bill went to Stanford School of Law and then joined the firm. So we've been around for 75 years now, and we have offices in both Fortuna and Eureka. Today, I'm going to talk about estate planning and the two different methods that most everyone is familiar with when it comes to estate planning are wills, which are subject to court jurisdiction, and living trusts, also called revocable trust, which are now mainly used just to avoid a probate. And so estate planning is an important tool to ensure that your wishes regarding your assets will be fulfilled after you've died. And wills and living trusts both primarily serve to provide direction as to how you want your assets to be distributed at your death. If a person dies and they don't have a will or a living trust, they're considered to have died intestate. And in California, the statutes under the probate code will dictate to whom their assets are to be distributed. And we call this the Law of Intestate Succession. And in some instances, if the Law of Intestate Succession comes into play, it can be contrary to the decedent's wishes. You know, oftentimes, if you're a widow or a widower and you die, your estate under intestate succession will pass to your children. But some people have falling out with a child or have a child that they don't want their money to go to. So it's important to formalize your wishes or in a will or a trust. Otherwise, it will be subject to the Law of Intestate Succession. Some assets, though, depending on how they are held or designated, don't pass according to the directions in a will or a living trust, and also aren't affected by this Law of Intestate Succession. And for example, we know that life insurance proceeds will pass to a designated beneficiary or beneficiaries that we named when we established the policy. Also, IRA or 401k retirement accounts will pass to named beneficiaries that we put in place when we set up those accounts. And securities held in transfer on death account will pass to named payable on death beneficiaries, as well as bank accounts that you can designate payable on death beneficiaries. Vehicles can transfer to jointly titled owners or to named transfer on death beneficiaries through the DMV when we do the initial title paperwork. Joint bank accounts will pass to the surviving account holder, and real property you own as joint tenants or as community property with right of survivorship will pass to the surviving owner at your death. And these assets all pass to the named beneficiary or beneficiaries you chose to be recipients upon your death or to the surviving co-owner, irrespective of whether you have a will or a living trust. Beneficiary designations and the joint titling of assets supersede any direction in a will or a trust, and they are often used for probate avoidance. This is why we see when most married couples are able to avoid probate at the first spouse's death. This is because generally all of their assets are titled jointly, and they just pass automatically to the surviving spouse at the death of the first spouse. However, an exception to this can occur if both spouses die together in an accident, or if the named beneficiaries or beneficiary or co-owner predecease you. Then these assets can end up coming back into your name alone, becoming part of your estate, and then therefore pass according to the law of intestate succession or according to the directions in your will trust. Aside from providing directions to ensure that your assets pass according to your wishes at your death, another one of the considerations looked at when doing estate planning is estate taxes. And because the federal estate tax rate is high, 40%, it is important when doing estate planning for high value estates to try to avoid or reduce potential estate tax obligations. In 2017, the estate tax exemption amount was about $5.5 million for a single person, and we can double that for a married couple. And then it jumped to over $11 million for a single person in 2018. And it goes up a little bit each year for inflation. And as of this year, 2021, as long as an individual dies with an estate value that does not exceed $11,700,000, then there won't be any federal estate tax consequences. This may change, however, while the $11.7 million exemption amount for an individual who dies in 2021 is high, and we in Humboldt County rarely see estates that exceed this amount. This is always a moving target for estate planners. In the year 2026, unless Congress makes this high exemption amount permanent, it will revert back to the $5.5 million that it was in 2017, with a little increase for inflation. And so prior to 2011, a living trust for married couples was the primary vehicle to try to reduce or avoid estate taxes. And this is because the trust had the ability to allow each spouse to maximize their individual estate tax exemption amounts. And the trust was used to allow each spouse to recognize all of the exemption amount up to the maximum, and to also pass on any unused portion to the surviving spouse. So in 2011, there were some tax law changes that allowed the estate tax exemption to become portable between spouses by filing with the IRS a Form 706 within 9 months of the first spouse's death. And this way, the surviving spouse could take advantage of the deceased spouse's unused exemption amount without having to formally have a living trust or transfer their assets into trusts. And if the surviving spouse's death, they would get the benefit of the exemption amount that was in place at the first spouse's death, added to whatever the exemption amount was in place when they died. So that portability has been a very nice thing for people who don't have living trusts to be able to utilize. And since the recent increase in the estate tax exemption amount from $5.5 million to practically $12 million, and now that we have portability between spouses, irrespective of whether they have established a trust or not, the main reason that I see why people continue to use living trusts for estate planning is for probate avoidance. And a probate is what we call the formal legal process of an estate administration when someone dies. A probate is subject to court supervision and will be necessary where a person died and they either had a will or they died intestate without a will, and they owned assets that exceeded $166,250 as determined by the court's own appraiser. And the reason that probates tend to be disfavored is mainly because of issues of time and expense. Probates can be lengthy, and generally a probate will take from 1 to 2 years before it is finalized. The court has certain requirements for giving notice to heirs and beneficiaries and potential creditors. And because of these notice requirements, at the outset, it takes 3 to 4 weeks just to be initially appointed by the court to act as the personal representative of the estate. And during this period, while waiting to be appointed, the personal representative has no authority and the estate just kind of remains in limbo until their appointment. And it makes a lot of people uncomfortable that they can't do anything during this period of time. In the best case scenario, probate can be closed in 7 to 9 months from start to finish. However, this is rare. It generally really is over a year. And aside from their lengthiness, probates can also be expensive. And in California, the fees to be paid to the attorney for the estate and to the personal representative for the estate are based on a statutory fee schedule that's calculated on a percentage of the overall value of the estate as determined by the court-appointed appraiser. And this fee schedule directs that 4% of the first $100,000 in value and 3% of the next $100,000 in value, and 2% of the next $800,000 in value, and 1% of the next $9 million in value, and so on, be calculated to determine the fees due to the attorney and the personal representative. And this is instead of just having an hourly rate multiplied by hours worked. So unfortunately, also in making the valuation, the court does not take into consideration the debts of the estate to offset that gross valuation. And so if a house is part of a probate and it's appraised by the court-appointed appraiser to be valued at $500,000, but it has a mortgage on it and it's encumbered, with a $300,000 mortgage, the house is still valued at that fair market value of $500,000 for the purpose of calculating those statutory fees. And so a lot of people have a hard time with that when there is a lot of debt in certain estates, that it doesn't reduce the statutory fee. So you can see with this multiplication of percentages that in large estates, statutory fees will be quite significant, and they really can be. Even in smaller estates, statutory fees can add up. And in my example that I see a lot of the time is it's just, a small estate. Maybe it's a residence and that's the only asset that's subject to the probate, and it's valued at $300,000. Well, the statutory fee for an attorney on a $300,000 estate is $9,000. And then the personal representative is also entitled to that same statutory fee of $9,000. So total statutory fees are $18,000. And then we have costs. So the Humboldt County Court has filing fees, and they're around $465 every time you file something in a probate. They have their own appraiser, and he charges an appraisal fee and time for his mileage, and he also charges for mileage if he has to drive. There's a requirement of publication for a probate, so the publication in the newspaper can be quite expensive. And in a typical probate, aside from the statutory fees, the costs can range from $1,800 to $2,500. So to get a $300,000 house out to your kids, it could cost your estate around $20,000. And so this is why a lot of people have a hard time with this. And so a living trust is one of the best ways to avoid probate. And a living trust is a document where you, as the settlor, the person who's establishing the trust, and the person who's funding the trust with their assets, and then you, that same person, are also the trustee named in the trust, and that's being the person with the power to control the assets. In that document, you make direction how you want your assets to be distributed at your death. And in the trust document, you appoint a person or persons who will succeed you that you want to serve as what we call a successor trustee. And so at your death, the successor trustee will have authority under the terms of the trust to control the trust assets, and they will manage and administer the trust estate pursuant to the directions that you have in your trust or any amendments that you made to your trust prior to your death. And the way that the living trust avoids probate is that your assets are titled in the name of the trust, and therefore they are subject to the terms of that trust document, instead of remaining titled in your name individually, which would trigger a probate. So if you have a house, it would be retitled by doing a deed from yourself individually to you as trustee of whatever the name of your living trust is. And so a living trust and its associated documents, it's a lot more complex than just doing a will, is about 5 times more expensive to establish than a will. But the way we think about it, you're either going to pay some more on the front end to save the expense of a probate, or end up just paying a whole lot more on the back end. And a living trust, when being administered by the successor trustee after your death, unless it's contested or something like that, has no court oversight like a probate. It is private. The documents are only provided to heirs and named beneficiaries, and they're not filed with the court in public record. What I see with living trusts is when I'm dealing with a trust administration where someone has passed, the successor trustees are often confused, and they have a misconception that they don't need to do anything. They think that the terms of the trust go into effect immediately, and they can distribute assets without delay to whoever the beneficiaries are. But like a probate, there are procedural administrative matters that are supposed to be done. And the most important is providing formal notice to any beneficiaries named in the trust and any heirs under the law to the decedent in order to take advantage of a 120-day statutory period for people to contest the trust. Otherwise, they're time barred from contesting. And if you don't provide that notice, then the statute of limitations never begins to run, and people could contest the trust at any time in the future. So there's some important things that need to be done. And because your successor trustee is acting in a fiduciary capacity to the trust beneficiaries, they owe a higher standard of care. And I think it's important that they retain an attorney to assist and advise them with the trust administration process. Even with an attorney representing them, a typical trust administration is still generally 50 to 75% cheaper than the cost of a probate. And while a living trust is not the only way to avoid probate, it is the way that, in my opinion, is best suited to deal with real property assets. And it allows for flexibility of changed circumstances and the establishment of contingency plans and that the majority of beneficiary designations fail to address. It also has the ability to plan for small children when people have children who are not old enough to take, that they want to make sure that maybe staggered distributions are made to them and that they don't get full distribution just when the settlors pass away. So that's kind of, in a nutshell, this overview that I wanted to talk about today, just generally estate planning, living trusts, and wills, and probate avoidance. And if anybody has any questions, I'm happy to answer them.
Yeah, I have a couple of questions, Amy. Thank you for your presentation. Thinking about, who you name as your successor trustee, is it best to find somebody who isn't a beneficiary? Is there an issue with having a beneficiary be your successor trustee?
No, there is not an issue with having a beneficiary be your successor trustee. However, they need to understand their fiduciary role. So when a beneficiary is a successor trustee and a beneficiary, there can be some conflict there. And so it's just they can serve in that capacity. It's just important to have an attorney walk them through things. Sometimes where a successor trustee is a beneficiary, they might want to take a certain asset as part of their share of the trust. And it just seems normal that they should be able to take, you know what I mean, as long as nobody disagrees. Let's say they want a house as part of their share of the trust. Then there is a perception sometimes that because there's this successor trustee, that they have some way of influencing this. And even though they're taking it for whatever the appraised value is, there's just certain precursors and paperwork that we like to do to protect that successor trustee from later claims that somehow they were engaging in self-dealing or somehow taking advantage of the other beneficiaries.
Great. Awesome. And so what would your recommendation be for someone who maybe is unmarried, doesn't have children, maybe doesn't have a lot of property, or maybe they do? You know, is a will sufficient? Should they look at doing a trust? What's your recommendation?
Well, it just depends. I mean, if they have total assets that exceed $166,250, so maybe they don't have property, but they have a bank account or an investment account, then I think that they really need to look at titling the assets or doing beneficiary designations. If they have small children and they want to be able to set up certain conditions and make a certain plan, then that can be done in a will or a living trust. And it really can't be done that well with beneficiary designations. So, you know, it just depends on what their plan of distribution is. And then they would kind of look at that and see what best serves to accomplish that. If they can do it with beneficiary designations, great. If they can't afford to do a living trust, then they can just do it with a will, and it will just go through probate. But they can definitely set up that same plan that they would do with a living trust.
Great. And then, so of course we have Supervisor Bushnell on the, so cannabis, you know, there's rumors that might be federally, you know, whatever, legal, I guess, recreationally. I don't want to say like whatever the descheduled. So do you foresee an influx, you know, if that comes to fruition, how that, you know, with federal banking, with cannabis money, do you think that might impact your industry as far as estate planning goes? Are you preparing?
Yes, I'm not preparing. Just take one day at a time. But I do think so. And so especially after 2026, if that estate tax exemption amount reverts back to the $5.5 million, I can see some of these cannabis individuals being somebody that would be subject to estate tax. And one of the things that they could try to take advantage of if they were kind of looking towards the future, and not just, you know, hoping that the estate tax exemption amount remains very high, is they can do gifting to, right now with that estate tax exemption amount of $11.7 million, they could be doing some things to try to get the value out of their estate while they're alive and reduce their potential estate tax exemption amount at their death. And a lot of people right now with the high estate tax exemption amount, you're able to gift $15,000 a year to anyone without any having to file a gift tax return or any gift tax consequences. And then if you gift over that $15,000 a year to any one person, that amount that exceeds the $15,000, you're supposed to file a gift tax return. And that amount comes off and reduces your estate tax exemption amount. And if you're gifting while this estate tax exemption amount is high, $11.7 million, then you can take advantage of that high exemption amount by making gifts and reducing the overall value of your estate, so that when you pass away later on, if it's, you know, $5 million, you've taken advantage of a big opportunity there. So I do think that that for single people who are making a lot of money in that industry, that we will be seeing them asking questions about estate taxes for sure.
Great, thank you. Those were my questions. Anybody else?
I have a question.
Yeah,
So
go ahead, Mike.
So is an executor the same thing as a, what's the trustee you named?
The successor trustee and the executor perform essentially the same role. It's just the executor does it in a court supervised setting, and the successor trustee has no court supervision.
So it depends on how you're designated in the trust as either an executor or a...
You would not be designated in the trust as an executor. It's always going to be a successor trustee. And a will is where we use the term executor.
Okay. And no matter what, if you have a will, it's going to go through probate, period.
If you have assets when you die that exceed $166,250 in your name alone, they don't have beneficiary designations on them, they're not jointly titled, then it will trigger a probate.
Okay, so as long as you indicate beneficiaries, then after all that's distributed, then the rest has to be less than 166,000.
Correct.
Yeah. And when you serve as a successor, then you get paid, right? It's like 4%.
So that's another little kind of a misconception. Most trust documents control the term about compensation to a successor trustee. And most trust documents just say that that successor trustee is entitled to reasonable compensation. And they'll have to get approval from the beneficiaries before they can be paid at the end of the trust administration, to make sure that their fee is reasonable. And generally in Humboldt County, sometimes it's an hourly rate times hours worked, where that successor trustee would track their time and they would pay themselves an hourly rate. And for what we see here is $35 an hour is a reasonable fee. Other times, people will want to take a percentage of just the overall value of the trust estate that's on hand for distribution to the beneficiaries, and to say, I'm just going to take this percentage. However, professional successor trustees like attorneys and accountants, the rate that they charge is like 1 to 2%. So a 4% rate for a layperson would be kind of unheard of. And generally, if I have a person acting as successor trustee and they're not a professional, we say, 0.75% to 1%. Unless the value of the trust estate is really low and they've done a lot of work, we would not go over that really small percentage rate. And we'd like to avoid doing percentage rates where it's not a professional trustee, but we do it.
Okay. And as a successor trustee, you don't need to hire an attorney. You can administer it yourself.
Yeah, so I think if you were skilled at understanding the intricacies of those things, those formalities that you need to do under the probate code, or be subject to basically having beneficiaries possibly come after you for not doing things properly, you can try to do it yourself. I do think that there are a couple of formalities that it would be important to have some attorney advice to make sure that you're doing those things that the probate code requires a successor trustee to do correctly. And one of the things that is required of a successor trustee is before they distribute the trust to the beneficiaries, they're required to provide them a formal accounting of everything that's happened from the time the decedent died to the time of distribution. And that requirement is an important requirement. All the beneficiaries, if they agree, can waive that requirement. But then if they waive the requirement and they're not provided an accounting, the statute of limitations issue comes up again, where that never begins to run because they never received anything to give them notice of transparency of what happened with the trust assets. And they could try to sue the successor trustee anytime in the future. So I do not recommend a successor trustee doing a trust administration without receiving some legal advice. There just are a few things that I don't think people would understand that they need to do.
Thank you.
Thanks for the question, Mike. Michelle, I saw you and Rex with your hands raised.
Thank you. Rex actually couldn't find the link, Renee, so that's why he's visiting.
I don't get invited.
I wanted to ask Amy, is it, hi Amy, it's
Hi.
presentation, it's very nice. Is it common when you name a beneficiary on your accounts that you name the executor of the trust, or is it not common?
No, it's not common. You would want to name beneficiaries who you want it to pass automatically to. If you name your successor trustee, that doesn't really work. What people do though, is they do name just the living trust, not the successor trustee, because we don't know who the successor trustee will ultimately be. You've named a person and maybe some alternates, and maybe that person that you put as the beneficiary designation died and they're not going to be the acting successor trustee. So you do want to just put individual beneficiaries if you want them, or if you're going to do the trust as the beneficiary, it's just the name of the trust, not the name of that successor trustee.
Okay,
And then it will flow into the trust and be distributed according to the terms of your trust.
okay, that makes sense. Thank you.
Renee might have had somebody walk in, I bet. Does anybody have any other questions? Go ahead, Mike.
Sorry. My question was, so what happens when the successor trustee gets challenged by the beneficiaries? Do they have to get lawyers and
So yes, the successor trustee can use the trust assets to defend themselves. And generally what happens if they're challenged is those beneficiaries actually have to initiate an action in the probate court. And it's then that brings the action like a complaint against the successor trustee in the probate court. And then the successor trustee can hire an attorney using the trust estate money to represent them to defend those objections or that contest. And those beneficiaries don't receive money from the trust for their attorneys. They need to pay out of their own personal pocket.
so they're essentially reducing the amount that they're going to get because the trust is going to pay attorney fees for the defense.
This happens all the time, unfortunately.
Wow. Thank you.
You're welcome.
I don't have a question, but I just have a comment. I wish more young people would hear this information with living, living trusts and wills. We learned by having to be, executors on both sides, my side and my husband's side, how we learned a lot with living trusts, and my husband and I have one now, and it's just really important to do that early on, and it really saved us down the line for both sides of our family. So it's just really good information to get out there, and really urge people to look into it because it is important. Just put your wishes down. And so it's, all part of the deal, but sometimes it's hard to keep putting it off, but good presentation. Thanks so much.
Thank you, Becky. Yes, it's expensive. People don't do the living trust because, this is not an area where many people have the resources to just plunk down the money.
Right. Yeah.
Okay, I have a question.
Wait, hold on. I saw Jeremy's hand up. Let's get Jeremy in there, and then Melissa, you can close it out.
Okay.
Go ahead, Jeremy.
Thank you for the presentation. I'm sorry I showed up late, so if you already answered this, I apologize. But is it possible for a parent to gift equity in a home to a child as part of that $15,000 gift?
So yes, but there are capital gains tax consequences with gifts. And so real property, if you gift a portion of a real property asset to a child, they acquire that gift at the same basis that you acquired it at. So later on, if they received a portion of that property by gift and that portion has the same basis that you acquired it at, and then later on they want to sell that property, there can be capital gains tax consequences. So it's always better to gift cash if you can gift cash, but yes, you can gift a portion of property.
Okay, I'll make mine really quick, and then Mike, I'll let you go, because am I next, right, Renee? Okay, so I am one of those young people that just got all of this done. And as you're talking, I'm listening, and I listened to my lawyer tell me all this stuff. And I swear we did a trust, but I don't know how many different types of trusts are there. Like, do I have a living trust because I am living, or is that trust something else that I have? Because I don't know what is what now. That you confused me.
It likely is titled, the Melissa Sanderson Living Trust or the Melissa Sanderson Revocable Trust, or just the Melissa Sanderson Trust.
Or is it a family trust?
Or the Melissa Sanderson Family Trust.
And it's the Living Family Trust. It's all one thing.
And by virtue of the fact that if you were told that you can make amendments to the trust at any time before you die, and you can make changes to it, it's what we refer to as a living or a revocable trust.
Okay, great. Okay, Mike, you can sneak in. Go.
I was just going to ask, how much does it usually cost to set up a living trust?
So my hourly rate is $375 an hour. And when I do a living trust from start to finish, and that includes titling all the assets and making sure those assets go and are appropriately funded into the trust, for a single, and this depends on the complexity of assets, how many assets a person has. This also depends on the complexity of what their plan of distribution is. Are they going to be controlling assets and making directions about certain properties and kids and what they can and can't do? But just as a general range for a single person or a married couple that have just a normal size estate, it generally ranges from 7 to 10 hours from start to finish. So, $2,500 to $3,700.
Okay, thank you.
Mm-hmm.
Michelle, I saw your hand pop up again. You want to? Yeah.
I have two questions. So when you have a living trust, when you purchase new properties, do you buy in the trust name?
Yes. So it's important when you establish the trust, you title your assets that you have at that point in time into your trust. When you're getting rid of assets, it doesn't matter. You can just get rid of your assets. But if you're acquiring assets, it's very important that you title them into the name of your trust or somehow direct that they will flow to your trust. Mm-hmm.
And my second question is, when you create a trust, is it a recorded document with the county, like a will, or how does it, so say my husband and I have a trust and we die, how does anybody know we have a trust?
Well, hopefully you have a copy of it somewhere that somebody can find. possibly have talked to your children about the fact that you have a trust. Possibly they know the law firm that you generally work with. We do a trust binder with our trust documents, and each of the documents has a stamp that says original document in the vault of the Harland Law Firm. And then that way, if somebody finds those documents, they know where their parents' original trust documents are. And so it requires, oftentimes somebody passes away and people aren't familiar with their personal business, and you have to check their mail and go through their personal papers and just, make efforts to try to find things. And then that's just how, unfortunately, sometimes how people come to get that information. But to the
So
extent that
is
you
it
should be,
I'm sorry, would it be common, like if whoever your successor is, that you would give them a copy? Would that
so
be?
no, I don't recommend when you do a will or a living trust to provide copies to your successor trustee or your kids or named beneficiaries, because changes can be made at any time prior to your death, and that can cause a lot of confusion, and then also contest issues where people are like, no, this is what they, it just causes issues. What I recommend is just communicating that you've named them in that role and that you do have a trust, and potentially where you keep your important paperwork if something were to happen to you, or who the name of your attorney is.
Thank you so much.
I got no money, I'm okay. All my successors get everything I owe.
Your beneficiaries get everything you own.
Awesome. Thank you.
I bet you don't have cattle that you've got to sparse out, so that's in our living trust. So
I do.
little of
I
everything.
do.
Yeah.
I have my horses named and my cows.
Yeah, there you go, Michelle. Okay.
Awesome. Well, Amy, thank you so much for the great information. I really appreciate it. And of course, as always, thank you for being ardent chamber supporters. We appreciate that as well. If anybody would like Amy's contact information, just give me a call. Otherwise, you can find her either in the Eureka office or the Fortuna office at Harland Law Firm. And thanks, everybody. We'll see you next Monday at noon. Enjoy your week. Thank you.
All right. Thank you.
Bye.
Thank you.
Bye.
Thank you all.